Okay, are you all set, Ryan? Okay. Good afternoon and welcome to the Senate Judiciary meeting of January 30th, 2024. We're going to open the day by starting the public hearing on Senate Bill 504 and recognize prime sponsors. Senator Bradley. Good afternoon, Mr. President.
Good afternoon, Madam Chair and members of the committee. For the record, Jeb Bradley, Senate District 3. This bill, Senate Bill 504, was brought to me by the Attorney General's office and the Governor's office. It changes current use posting for purposes of allowing the posting of no trespassing signs. The current law enables people who put their land into current use to receive a 20% reduction in their tax assessment if they open their property up for certain kinds of recreation that are enumerated in the statute: skiing, snowshoeing, fishing, hunting, hiking, and nature observation. It does not open the current statute, I'm told, for things like OHRV use or other possible recreational activities like that. It's just those that are enumerated in the statute. But in order to get that 20% discount, you cannot post no trespassing signs. The reason behind the bill is that there is a huge amount of current use land in the northern part of New Hampshire, which happens to be the American-Canadian border, and current law, federal law, would allow federal authorities to interdict people crossing our border illegally, but state law enforcement cannot do that. And so in order for state law enforcement to be able to assist in interdicting people that are crossing illegally, creating the no trespassing crime is the purpose of Senate Bill 504, so that New Hampshire law enforcement could take independent action separate from CBP, Customs and Border Patrol. Why is this bill necessary? In New Hampshire and in 49 other states, we have seen the results of open border policies. Not only human trafficking, but the import of illegal substances, in particular fentanyl, flowing across our southern and our northern border. Every town in New Hampshire is subject to the fentanyl crisis. We debated these issues in the budget last year because at the governor's request, we funded $1.4 million to enable local law enforcement to be able to help protect the border. And the reason for that is, according to the Northern Border Alliance Task Force, there have been about 7,000 illegal interactions that have occurred in the so-called Swanton District, which stretches from New Hampshire to Vermont to New York. And that's up significantly, and that's why we allocated that $1.4 million. I believe, and I hope that you as members of the committee believe, that protecting our northern border to prevent drug smuggling, human trafficking, and illegal entry into our state is important. So the bill makes it clear that a landowner may post no trespass signs. So I've asked the committee to look at a potential amendment that makes a small change to the bill. And that amendment is 314, which you have before you. It was brought to my attention by the Timberland Owners Association that the way that the original bill was drafted, if you look at that on line 6 and 7, an owner of open space may post no trespass except for public recreational use. Well, that term, public recreational use, is broader than what the statute currently allows. And so this amendment restricts it to the recreational activities enumerated in the statute of skiing, snowshoeing, fishing, hunting, hiking, or nature observation. So, as I said before, the rationale for the bill is much of the North Country, especially on the border, is land in current use. In order to enforce, or for local law enforcement to enforce, there needs to be the ability for property owners to post no trespassing so that our, whether it's state or county or municipal law enforcement, can interdict people crossing our border illegally. So I commend this bill to the Judiciary Committee, and Madam Chair would be happy to answer any questions.
Thank you very much for your testimony, Mr. President. Are there any questions for the committee? Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. You had mentioned that there were 7,000 incidents of interdiction or for illegal crossings on the northern border, which is New Hampshire, Vermont, and New York. Do we yet have the data? I know this was a big topic of conversation. Do we yet have the data of how many of those 7,000 went through our New Hampshire border?
I'm not sure I know the answer to that, but it is a broad problem over those 3 states that porous border policies have enabled. And in my view, there's no significant disincentive if the federal authorities are not enforcing immigration law. And given the problems that we're seeing with widespread fentanyl use, human trafficking, et cetera, creating a disincentive on the northern border is very important, given that there has been, according to Customs and Border Patrol, a large increase in the number of interdictions over the last several years.
Follow up?
And do we have any evidence that the federal government isn't enforcing federal law at our northern border?
Well, if you recall, Governor Sununu asked President Biden in a letter this fall for more resources to enforce border security on the northern border, and that was never answered. And there have been no resources forthcoming. So, yes, there is a problem.
Are there any further questions? Seeing none, thank you very much for your
Okay.
testimony, Mr. President.
I believe that Mr. Bond from the Attorney General's office is here and
Yes,
can answer any specific questions.
thank you very much. The chair will call Christopher Bond. Good afternoon, Mr. Bond.
Good afternoon. For the record, Christopher Bond, Associate Attorney General from the New Hampshire Department of Justice. And as Senator Bradley noted, the Attorney General's office is in support of this bill with the amendment he described, and I'd be happy to take any questions.
Senator Whitley.
Thank you, Madam Chair. I'll ask you just similar questions because
Sure.
I think that's really important in our consideration that we heard that there were 7,000 interdictions of illegal crossings on the border of New Hampshire, Vermont, and New York, but that's a fairly large area. And so do we have, or do we plan to figure out how many of those illegal crossings happened in New Hampshire?
Yeah, you're correct. I think it's a 203-mile border or something. So much of it is not New Hampshire border. I don't know those numbers. I know those are maintained by the federal government and not by New Hampshire. I am not aware of any efforts to find that out, but I'm happy to look into that. It may well be that our office is trying to determine that, and I'm happy to circle back with you with information on that.
Yes, follow-up?
Yep, if you could get those numbers and share with the committee, I would really appreciate that. And then the other question I sort of asked, it sounds like the reason why this bill sponsor thinks it's important is that he identified an issue of the federal government not enforcing federal immigration law along the northern border, and I'm not aware of that. And so I am curious, is there any evidence that the federal government is not enforcing its own law on the northern border?
So I do know that we've had communications from local law enforcement in our office that the federal government has been pulling resources off the northern border and diverting them elsewhere, including to the southern border. But I don't have statistics on that for you. But again, I'm happy to look into that and see if I can get you some information specifically.
Follow-up?
And more specifically, it sounds like they're pulling resources to bring them to the southern border, and it would be good to know, is it because that there isn't a problem on the northern border, or is that the problem really is on the southern border rather than the northern border? Thank you.
Sure. Obviously, I can't really speak to the southern border. I do know that we do know that the amount of interdictions over the last several months, or the last, say, 24 months, have been significantly higher than in the decade prior to that. So we are seeing a lot of increased activity on the northern border. You're correct. There may be even more increase in the southern border that the federal government has to try to balance it out. But whatever the reason for the pullback, the Attorney General's office thinks it's important to give local law enforcement as many tools as possible to assist however way is appropriate for them.
Thank you.
Are there any further questions? Seeing none, thank you very much, Mr. Pond.
Thank you.
Okay, the chair will call Jason Stock.
Good afternoon.
Good afternoon.
Jason Stock with the New Hampshire Timberland Owners Association. And I indicated on the sign-in sheet that we oppose the bill. And you heard the reasons why from Senator Bradley. We think the amendment does fix that concern. The concern was what is, quote, recreational use. And for people to be posting signs saying no trespassing except for recreational use, well, for me, riding my dirt bike up and down a forest road might be considered recreation, but it was not the intent of the current use law to allow motorized recreation without landowner's consent. So we think this amendment clarifies that if you're going to post a sign up saying no trespassing except for, and then that just keep it specific. So we think this fixes what was our concern.
Okay,
Thank you.
Thank you very much, Mr. Stock. Are there any questions for Mr. Stock? Okay, seeing none,
Thank you.
thank you. The chair will call Robert Johnson. Good afternoon, Mr. Johnson.
Good afternoon, Madam Chair, members of the committee. For the record, Rob Johnson representing Farm Bureau. And we indicated again in our card that we were in opposition to the bill as introduced. We can live with the amendment. What I just want to point out is that there is no program in the state that's more important to our working farms and forests than the current use program. And that's why we're concerned with any additions or changes to the statute. It's our program, if you look at it compared to other states' open space programs, current use programs, is very simple. We want to keep it that way. As President Bradley noted, that this is clarifying language, and that's simply what we see. A landowner can already do this, but it clarifies the law and also satisfies the goals. So I'll leave it at that. Thank you for your time and attention.
Thank you very much, Mr. Johnson. Are there questions from the committee? Seeing none, thank you. The chair will call out Charles Levesque. Good afternoon, Mr. Levesque.
Thank you, Madam Chair, members of the committee. I do have some written testimony, so I'll give it here. I'm Charles Levesque. I chair an organization that was founded in 1968, the Space Organization, statewide program of action to conserve our environment. Space is the original advocate for current use for the constitutional amendment that passed in 1968, and so we've been around since then. It's a current use coalition. Some of the speakers you just heard from are part of this coalition. I signed up in opposition to the original bill, but Space also can support the amendment. So as you have it with the amendment, makes sense to us. As Rob Johnson said, this is the key statute we have when it comes to land conservation for working forests and working farms and open space. And so we are always concerned when an amendment to it is proposed. And what I sent to you, I encourage you to flip over the page and look at the map on the back, because this may be helpful trying to understand what's going on in the North Country. This is a map of Pittsburgh, New Hampshire, the very tip of New Hampshire. That which is colored black, green, and red is the border with Canada. And I would just like to point out, so that you understand, the sections that are black and green cannot be posted against access, because that's part of land that was purchased, or conservation easement that was purchased 2003 with a combination of state funds and U.S. Department of Agriculture funds through the Forest Legacy Program. So the border itself has three main sections in terms of the ownership. The black, as I said, is the private land covered with a conservation easement that is now owned by Aurora Sustainable Lands. That land cannot be posted because of a conservation easement on it. The green part, which is where Route 3 heads into Canada, is a border of fee lands owned by the state of New Hampshire and managed by New Hampshire Fish and Game. And on the bottom left-hand side, in red, is a series of about a dozen private landowners who own that land, some of which, maybe all of which, could be in current use. I don't know exactly. But I thought that would be helpful in your discussions, because I'm not completely convinced that even with the amendment, this is necessarily going to accomplish what the Senate President wants and what probably law enforcement needs to deal with the illegal entry. And I'll leave it at that. Thank you much.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much. Are there any other members of the public who would like to speak to Senate Bill 504? Okay, seeing none, we'll close the public hearing. God, that blows so much air. It blows. You ready, Ron? We're going to go ahead and open the public hearing on Senate Bill 314 and recognize prime sponsor, our own Senator Shanley. How are you?
Very good. Thank you so much, Madam Chair, members of the committee. My name is Shannon Chandley, and I serve the people of Senate District 11. I come before you today to introduce Senate Bill 314 relative to pretrial competency evaluations. And I want to say off right at the start that I brought this bill forward at the request of the Department of Corrections. As we know, administering justice always requires finding a balance and making sure that everyone's needs are met to the best of our ability. This bill aims to address the struggle to find qualified providers for competency evaluations, as well as to deal with folks who fail to show for evaluation by providing certain incentives. And it also aims to reduce the need for evaluations, the requirement for evaluations if the need is not there. I would suggest that the commissioner is here and she can speak to this much better than I, and I appreciate your considering this bill. Thank you.
Thank you very much, Senator. Are there any questions? Seeing none, thank you.
Thank you very much.
Commissioner, you haven't signed up, but would you like to come forward at this point? Just make sure you identify yourself for the record.
Thank you, Madam Chair, and members of the committee. For the record, my name is Helen Hanks. I'm the Commissioner of the Department of Corrections. And to my right, I've brought Director Paula Mattis, who has been
Okay, Paulus.
definitely intimately involved in this process, as we both have through our tenure and career, and we appreciate the opportunity for this piece of legislation to be considered and discussed.
Hi, pardon me. Again, Paula Mattis, Director of Medical and Forensic Services for the New Hampshire Department of Corrections. And I do have written testimony and, oh, thank you, ma'am. And also a picture to describe and explain further the challenges we all face. So as Commissioner Hanks stated, Paula Mattis, Director of Medical Forensic Services, and I want to thank you all for your time today. We are coming out in support, clearly, of SB 314. And we have some background information we'd like to provide to you, which is, I'm not going to read it verbatim, but it is in the written testimony that the Office of Forensic Examiners, while falling under the Department of Corrections, is actually part of a contract we have with a larger entity known as Wexford Health to provide certain services to the state of New Hampshire, specifically the Department of Corrections. And they are the organization that is responsible for vetting, hiring, and organizing the service we all know of as the Office of Forensic Examiners, which I'll probably call the OFE during my conversation with you all. We have for quite some time now been experiencing challenges throughout the state in hiring qualified professionals in all walks of life and across all agencies, both in private and in state organizations. We have a history of providing this service, the state of New Hampshire, which started out late 1990, maybe back as far as preceding both of us in our state service. And so we're going to speak to the more recent time, which is roughly in the early 2000s. There was one person providing these services for the state of New Hampshire. Over time, it grew to 3 evaluators, and now we are up to the present, where we now have 5.8 evaluators to do the work of the Office of Forensic Examiner. It's important to note that these professionals are specially trained psychologists who do conduct these evaluations in order to assist the courts in making a determination. We have looked at that part of the pie or the puzzle, so to speak, and it doesn't appear that there is either an increase or a decrease in the number of these professionals available throughout the country, because other states, we know from different groups we're a part of, are experiencing this same challenge with increasing orders and not enough staff to fill the need to meet those orders. Again, we're here today because New Hampshire is one of those states. Wexford Health, who is responsible for the recruitment of these staff, are aggressively searching to fill these positions. They have, we prefer that they hire one full-time equivalent, in other words, a full-time evaluator. But because of the shortage and the need, we are contracting individual evaluations and doing those, some of those, if appropriate, through telehealth. We monitor their progress and the techniques they are using to recruit, and have done that periodically throughout the inception of this contract, and believe they are making all efforts in order to fill those positions. Yet we still remain in the position where we don't have enough staff to complete the higher number of evaluations. The other part of the puzzle is that, and if you look at the graph that the department has prepared, you can see that the number of evaluations continues to grow. The roughly top half of the graph starts showing in fiscal year 2016 through fiscal year 2022, which is our most recent data. And you can see that the numbers keep growing. And then the number of evaluations are in the top half. I'm so sorry. The number of orders, which would be roughly the bottom third of this page, you can see the increase over time as well. For fiscal year 22, we received 819 total orders from the courts for these very specialized evaluations. Again, the challenges we've enumerated and we'll talk a little bit more about. So this is roughly a 20% increase from the previous years, fiscal year 22 over the previous years. These competency evaluations are raised both involving lower level misdemeanor crimes as well as felony charges. So we are talking about a group of citizens who are charged with certain crimes that can range from anything from something as what we might call a nuisance crime, such as trespassing repeatedly, all the way to serious assault and murder. So when we are talking about this population, it's important to note we are not talking about the same level of crime or behavior that you might think when you start hearing the word competency evaluations. It's very common for people to think we're talking about serious crimes such as rape, murder, arson, and serious assault. So again, we're here talking about, we've presented this legislation because we continue to see the orders move up. The number of qualified people to do this job is not increasing. Again, it's not diminishing, but it's not increasing, and we are not able to meet the demand. The other piece of this puzzle, which creates a problem for the state of New Hampshire, the number of no-shows. We schedule evaluations. Evaluations typically take, it can vary, but let's say on average 3 to 4 hours. So if you don't show up for that appointment, that is a huge block of time that we cannot fill. We try. I want to be very clear. We try. We make some calls, but people are not always sitting by the phone or willing to answer the phone. And some people are not invested in taking care of themselves or taking care of business. So all of this contributes to the no-show rate. We do try. We have a list. We reach out. Sometimes we're rarely successful in filling those no-show slots. Again, we think Senate Bill 314 creates an incentive for individuals to appear for their court-ordered competency evals. Again, keeping in mind that 25 to 30% no-show rate. It's hoped that by having consequences as proposed in this bill, it will reduce that no-show rate and help contribute to decreasing the backlog, which is a concern to all of us, all constituents in this matter. We also propose in this bill, that when a defendant is deemed non-restorable, that the court recognizes and all involved that restorability is not going to be occurring, that the existing legal authority dismiss the charges without prejudice. This provision, already existing in New Hampshire law, aims to instill confidence within the judicial branch that they may refrain from recommending a defendant for evaluation when circumstances are straightforward. And there are some cases that we believe are straightforward. In encouraging that, again, that utilization of what's already existing in state law will help to contribute to decreasing the backlog. Finally, and this is a problem that is known to people that do these kind of evaluations. To do a really good evaluation, you want past records. We're talking about an evaluation done by highly skilled professionals who can get information from the person that the accused or the defendant in these cases, but will also benefit from records from schools, again, depending on the age of the defendant, past evaluations, past involvement in the mental health system, past hospitalizations. And we have a problem in this state where even when the court is ordering these records, that there is not a follow-through, that we don't get those records, and it makes it very hard to do a thorough evaluation. We believe Senate Bill 314 fixes that as well. We are, as a department, very committed to serving the state of New Hampshire, making sure that quality evaluations are done, and we are continuing to invest a huge amount of effort in making sure that happens. But we believe there are some, what I would call institutional or system barriers that can be remediated through passage of this law. And I'm available for questions, as is Commissioner Hanks, if we can answer any questions.
Thank you very much for your testimony. Are there any questions? I have a few questions, and I'm just going to run through them. You talk about the 25 to 30% no-show. These mental health professionals, they're being paid for this lost time. We can't expect them, it's not like on a per person basis. So they're paid a flat rate and that's it.
Okay, well, I'm sorry. That is correct. This is part of the contracted staff. There is an option in the state. There are private evaluators that are available for the courts to use, and that's a different funding structure that we can't speak to. But those employed primarily in the Office of Forensic Examiner, it is, as you say, Senator.
My second question is, and again, it relates to this very high no-show rate, and you know, we have this here to talk about the number of orders, fiscal year 2022. Most of the people are out on bail. Now, when there's a question about the competency of an individual who's being accused of a crime, and the court orders that an exam is done, is that made a condition of bail, meaning that we're going to give you bail, but you will go to this. So that way, if they don't show up, you can report them and they will lose bail.
Senator Carson, thank you for that question. It adds another element. So the answer to that is, yes, that opportunity exists if it's part of their bail condition. But I also want to be clear, the competency evaluation process, we're actually not a party to the matter. We're a service. And so that action is definitely left to the prosecuting attorney in this case and the defense attorney. And that in and of itself, that we're not really a matter to the matter, has created many challenges as we're trying to fulfill this service.
Thank you. And I have one last question. The language that you discussed, that in instances where a defendant is deemed non-restorable, when you say non-restorable, that means that there's really nothing you can do to restore that person to mental competency. So I want to make sure I understood that. And also, the court possesses the existing legal authority to dismiss the charges without prejudice. I don't know, is that holding someone responsible for something that they've done? And where are the victims of the crime? Whether it can be a property crime, as you said, it can go all the way from here to here. I would hate to see somebody who is known to be mentally incompetent commit a violent crime against someone, but it's just dismissed with prejudice because they are mentally incompetent. That doesn't seem right in our legal system. Can you expand on that a little bit?
Senator Curzon, I will, and I do want to point out a member of the Attorney General's office, Attorney Grandy's here, who may dive into that a little more deeply to assist in your
Okay.
question. I will affirm for you that that language exists already. And in those cases, when someone cannot be restored, both the evaluator and those involved understand that. What has been usually the path is an involuntary commitment because of the origin of the reason for non-restorability. And I know you're quite familiar with those commitment laws, and that's the path for public safety, and to keep the victim and survivors in some cases whole.
Okay, thank you. Are there any further questions? Okay, seeing none, thank you very much for your testimony this
Thank you so
afternoon.
much.
Okay, next we are going to call Henry Klemenowitz. Good afternoon.
Good afternoon, members of the committee. Thank you. My name is Henry Klementovich. I'm a senior staff attorney at the ACLU of New Hampshire. There are two parts of this bill that we oppose that I just wanted to flag for the committee. The first involves Section 1F, which authorizes the court to require the defendant to produce to the prosecution all records related to the issue of competency. These type of records that we're talking about that would be probative of competency are usually doctor-patient records, mental health prescriber records, the type of things that we typically think of as both privileged, potentially protected by HIPAA, and just generally confidential medical information, especially since the competency proceeding is not voluntary on behalf of the defendant, both in the fact that they didn't voluntarily choose to get arrested, but also that other members of the court, including their own attorneys, can raise the issue of competency over the defendant's objections. We view that there's an issue that people might be less forthright with their mental health providers if they knew that that information was going to be turned over to the prosecuting agency. And then additionally, the statute, so we don't have a problem with that information being turned over to the forensic examiner. It's just turning it over to the prosecutors, especially given that there's no carve out for evidence that may be relevant to both competency and the underlying criminal act or case. And so that strikes us as sort of incongruent with the principles of presumption of innocence, the state's burden of proof, and the right to remain silent. And then second, and I certainly understand, even more so listening to the Department of Corrections presentation, why this request was put in. Section 1A, which authorizes competency evaluations to be conducted by appropriate electronic means. We, of course, don't have a problem with that happening where all the parties consent, or at least where the prosecutor and the defense counsel consent. But would be concerned in a case where, competency is raised as an issue, the defense or the defense attorney or the judge or the prosecutor who's raising it as an issue thinks, this competency evaluation really needs to happen in person because of particular reasons, and that doesn't happen. And that strikes us as something that could be potentially a problem. State versus Veal, which is a 2009 New Hampshire Supreme Court, recognizes that there is a due process interest in a person being declared incompetent to stand trial. And so there are procedural safeguards that have to happen. And, I'm going to be forthright with the committee. I've never been involved in a competency proceeding, but have talked to practitioners who have. And sometimes you really want the examiner to observe all of the mannerisms of the person. How do they look? How are they presenting? What's their hygiene level like? There are those kind of things that maybe you just can't observe through Zoom. And so that strikes us as a risk of people being erroneously declared competent and thus, perhaps being subject to an unconstitutional prosecution, or erroneously declared incompetent, which, there's the risk to the broader justice system, to the victim, and to the person's liberty, interest, and their good name. So those are the two problems that we have with it. I think there are probably ways that could be addressed. Happy to work with anyone at any time afterwards. Thank you. I'm happy to take any questions.
Thank you very much for your testimony. Senator Whitley has a question.
Thank you, Madam Chair. So on that latter point, would it allay your concerns if it said whether in person or via appropriate electronic means, if we add something in there with the consent of the defendant?
Probably. I mean, I'd like to take a look at the language and talk to people more knowledgeable about this than I, but yes, I think that there is at least that part of our concerns could be allayed with language like that.
Paula?
Yes.
Instead of just doing this in committee hearing, if you don't mind sending proposed language that would allay your concerns, I think that might help the committee.
I would be happy to do
Thank
that. To the committee.
Are there, Senator Chandler?
And similarly, thank you very much for your testimony. I just want to make sure I understood you correctly. That Section E, the requirement to provide records to the examiner, you don't object to, but it would be to the prosecution.
That's right. I think that, I imagine that the examiner might look at it and say, knowing the person's medical history would be relevant and helpful. And so that makes sense to me. I don't have a problem with that.
Thank you very much.
Okay. Are there any further questions? Seeing none, thank you very
Thank
much
you
for
very
your
much.
testimony. The chair will call Jeffrey Odland.
Good afternoon, Madam Chair, members of the committee. Thank you for the opportunity to address you on Senate Bill 314. For the record, my name is Jeffrey Odland. I'm the president of the New Hampshire Association of Criminal Defense Lawyers. I'm here to testify in opposition to the current form of the bill, to make suggestions and voice some concerns which are similar to those addressed by Attorney Klementowicz on behalf of the ACLU of New Hampshire. My association shares the same two concerns with respect to the current formulation of the bill. Unlike Attorney Klementowicz, I would note to the committee that I am someone that has participated as defense counsel in numerous competency proceedings. I would estimate I've been present for at least 50 competency evaluations during my career, potentially substantially more, and been counsel in numerous contested competency hearings. I think it's helpful for the committee to understand, in essence, how competency becomes a legal issue in court, and then what that legal determination is, because it sort of informs my concerns with respect to the use of Zoom or WebEx or some sort of virtual evaluation process. So the Supreme Court of the United States has said that defense lawyers have a constitutional obligation to a criminal defendant not to allow them to be subject to prosecution unless two things can be shown: that they have a present ability to consult with their attorney, and that they have a factual understanding of the proceedings against them, which might mean either to make sure that either they understand factually what they have been accused of, and also that they understand factually what's happening in a courtroom. Who is the judge? What does the judge do? Competency can be raised by defense counsel on the basis of an intellectual disability or a significant mental illness. And once that is raised by defense counsel, it in essence causes a pause in the proceedings, because the case of Dusky versus United States, the Supreme Court said that it violates due process to go forward towards a criminal penalty if someone doesn't meet those two prongs. So I would focus the committee's attention on the second prong, that when the evaluator is meeting with the defendant, they're doing a evaluation, which is a psychological evaluation, but it's to offer an opinion that's in essence a legal opinion in many ways. And that opinion is, does the individual before the evaluator have a factual understanding of the proceedings against them, but more importantly here, a present ability to consult with counsel. And that second determination, can they work with someone, in essence, is really about rapport, and whether the person will be able to forge through whatever intellectual deficits they may have, mental illness they may be suffering from, and work with someone as an advocate on their behalf. And I think that this really cuts in both directions. It might be that someone on a Zoom interview may seem incapable of building rapport, but if they were in person, the examiner could build that rapport with the individual. And it might be the opposite. And so I think, especially in serious cases, you're never going to get an accurate view of whether someone can work with someone else unless you're in a room with them. There's also standard questions at the beginning of any psychological evaluation about whether the person was oriented to the space around them. Did they sort of understand where they were? Were there hygiene issues that were observed that might show an underlying mental illness? And the basics of the mission of the evaluation are frustrated, in my opinion, unless that occurs in person. Now, there may be circumstances where the issue is fairly straightforward and clear-cut, where the individual has been evaluated several times because of a long history of mental illness, and the parties may think it's appropriate to conduct the evaluation by Zoom. And I don't have an overarching objection to the cost savings that offers. But I think that as the exchange with Senator Whitley took place earlier, I think that language would need to be inserted in the bill that only occur upon an agreement of the parties, but that in the first instance, the default would be for an in-person evaluation. Similarly, as the prior speaker addressed, I have broad concerns with respect to Section F that would authorize the court to order the defendant to provide the prosecution with all relevant records related to the issue of competency. I have several concerns just about how broad that language is. First of all, it's unclear who is being compelled. The plain language of the statute says the defendant, but this is in the context of a criminal case, so it's unclear whether defense counsel would also be considered to be the agent of the defendant and therefore ordered to provide any work product or notes they have as a part of the representation, which would impinge on attorney-client privilege. It's unclear what records mean. I assume from the overall statutory context, it means mental or medical records, but it doesn't say medical or mental records. It just says records, which again, seemingly could encompass attorney work product. Additionally, both attorney work product and mental health or medical records could include incriminating evidence within them that would be compelled, the production of which would be compelled by the current statutory language, which we believe would present a Fifth Amendment issue that an individual whose lawyer believes may not be competent to stand trial would be compelled to present not a neutral forensic evaluator, but the prosecutor in the case with all possible records, we think would run afoul of the right to be free from being compelled to incriminate oneself and violate both the state and federal constitutions. And so for those reasons, we would oppose the current language there, but would be happy, as Senator Whitley mentioned, to perhaps propose some amendment language if the committee was interested. And if there are any questions, I'm happy to take them.
Thank you very much for your testimony. Are there any questions? Senator Whitley.
Thank you, Madam Chair, and thank you for that clarification. I'm just hoping that you can work with the ACLU and the bill sponsor on some language.
Happy to do so.
Thank you.
Are there any further questions? Seeing none, just a quick question. If someone has a prior mental health diagnosis, do you think that should be given to the Department of Corrections in lieu of having to go through another exam?
I do, Your Honor. There's a section of the bill that, Section E, which is the section that would require defense counsel to provide at least 3 years of historical mental health records for the defendant to the OFE directly, in other words, to the evaluator. And we don't have any issue with that. I think that's clearly information that's relevant to the determination that evaluator needs to make.
Okay, thank you. Are there any further questions? Seeing none, thank you very much.
Thank you.
I do have a Mike Grandi from the AG's office, but they did not specify whether or not they wanted to speak. Would you like to speak briefly, please?
Thank you, Madam Chair.
I'm really here to answer any questions that the committee might have, if there are any questions about what has been testified to by the sponsor of the bill, but I don't have any particular testimony to offer at this time.
Does anyone have any questions? No? Thank you very much. Okay, are
I
there,
do have a question.
oh, wait a second, sorry, please come
My
back.
apologies. My question is simply that we've talked, there's been a little bit of sense that we may consider modifying this a bit. It's now in the committee's hands, and the committee will work on it, but you will be available if we have questions after this.
I will.
Thank you.
Okay, are there any other members of the public that would like to speak to Senate Bill 314? Okay, seeing none, we'll close the public hearing. God, that thing is so cold. It's like, it's air conditioning. It's air conditioning. Air conditioning. blowing up.
Yeah, we go.
Okay. Yeah, we've got to figure out how to maybe turn it. Yeah, it's just like. Senator, I'm next. You're after me. Oh, you're not up to this. Let me not come in the middle. You're so enthusiastic. You wanted to introduce the. All right, just want to be there. Yeah, it's like. It's like you're getting a tropical breeze, but it's like 40-degree tropical breeze.
Okay, good afternoon, Senator Carson. You're introducing 460.
Yes, good afternoon, Mr. Chairman and members of the Senate Judiciary. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon Senate Bill 460, which seeks to establish the crime and penalties for unlawful use of unmanned aircraft systems. Mr. Chairman, the rapid evolution of technology and availability of low-cost, more capable small unmanned aircraft system, or SUAS, represents a myriad of threats to public safety in the Granite State via both negligent and nefarious use. New Hampshire law currently lacks the prohibition and penalties necessary to protect against negligent and nefarious use of these devices. This legislation is an important step towards ensuring the safety of New Hampshire citizens and the protection of our critical infrastructure from the threats posed by these SUAS. And just to give you an example, on August 23rd, 2023, a DHART medical helicopter was grounded for 10 minutes due to a small drone flying at the incident location, delaying the care of a critical patient. So when we're talking about these SUAS, these are small drones that we're talking about. So, Mr. Chairman, at this point, I will conclude my testimony. There are individuals here from the department that can answer your questions better than I can.
Thank you very much, Senator
Thank you very
Carson.
much.
Lieutenant Chris Storm. Good afternoon, Officer Storm.
Good afternoon, Senator Gannon. How are you?
Doing great.
Thank you very much for allowing us today to testify to this bill. Senate Bill 460. So the Department of Safety, along with several other groups to include our friends from the Bureau of Aeronautics, our friends from the Department of Corrections, have all worked together to basically craft this legislation to help stymie this problem that we're seeming to have here in New Hampshire. I just jotted down a few notes, reference to our support for this bill through the Department of Safety. First and foremost, basically what this bill is trying to do is basically adopting the already federal regulations that are consistent with drone regulation. So 49 CFR Part 107. That is the current federal legislation for what we refer to as, again, the small UAS. We're basically asking for these laws that are already federally established to then come to New Hampshire so that we're actually able to do something. Currently, right now, we cannot do anything with anybody that's doing anything that's against the federal laws. So this would be very close to something how we enforce our federal motor carrier laws with our big trucks and so forth, basically adopting those laws so that we can actually do something about it. We can actually summon somebody, but unfortunately, maybe potentially arrest somebody for doing one of these particular crimes. A couple things that we would like you to understand is that we're not trying to stop drone activity. In fact, drone and the use of drones is a very good thing through commerce, through a plethora of different things, public safety, educational stuff, agriculture, all that. We're not trying to do that at all. Basically, what we want to make sure that is if someone is doing something nefarious or someone's doing what we call the careless, the clueless, or the criminal, that we have a way to actually enforce this law. Our strategic threat assessment for the state has identified this as a very serious threat that we have, to include watching stuff like if anybody was watching NFL this weekend, they had to stop one of the games due to a small drone that was flying over the crowd. They've had instances at Fenway Park, as Madam Chairman was talking about, the DART incident with the Dartmouth medical helicopter that's interfering their ability to deliver care to a patient. We find that to be something that we get these calls almost every day. The Bureau of Aeronautics will speak to it. They get calls every day relative to people that are doing something, and there's nothing that we can really do to stop this problem. So we are in support of this legislation, and I'll take any questions that you have relevant to this.
Thank you very much for your testimony. Are there any questions? Senator Chandley.
Thank you very much, Madam Chair. Thank you for taking my question. I remember, I mean, this issue is not new. I do remember, I think it was in the 2013-14 session. We had a number of, this issue came before us, a lot of concern over contraband being dropped in prison yards and county jails. But what I recall from that testimony then was that we were somewhat handcuffed in terms of our ability to act because of the FAA's right to control the airspace. So has anything changed, or is this written in a way that accommodates that?
Exactly, Senator, that you're 100% correct. It is written that way so that we can then enforce that, because you are correct. We cannot establish anything that airspace is sovereign, and there's nothing that we can do about that, and we cannot enforce those airspace laws. This is written in that context that we adopt that so that we are able to deal with that situation.
And if I might follow up?
Yes, follow up.
I'm curious, we'll just use the example of the Dartmouth helicopter being unable to provide the care necessary. Was that if it was accidental, I don't know if it was intentional or accidental, if it was just that, how would you approach it? How
we would approach it now is, and collectively as a group, we've talked about this. We're going to first educate, obviously. If something obviously comes to life or limb, we are going to take, more drastic action. But we have to educate people first, right? We can't just go all the way out there and start writing tickets or arresting people because they're doing something. We are going to speak with them. They haven't done an investigation on this, and it's gone to the FAA. The FAA is best way of putting this right now. There's not many people up here to assist us when it comes to dealing with these situations. But we would talk with that individual, we'd explain to them that they are interfering with that and so forth. And this bill gives us the ability to then maybe issue them a citation. Instead, we're not saying we're going to put them in handcuffs and take them away because they did that. But if they strike an aircraft, if they, they cause a delay in someone getting critical care, then we could absolutely have the ability to then to cite them or to fine them for doing that.
Thank you very much.
Are there any further questions? I just have a quick question. My colleague asked the question that I was going to ask because this is an issue that keeps coming up again and again with drones, that they're governed under federal law. But what I'm concerned about is you see people driving along the highway, accidents happen, people sending drones because they want to see the accident. And as we know, a lot of drones are capable of taking pictures. And I know we've had legislation in the past dealing with reporters and people like that coming up upon an accident scene and interfering because they want to get pictures. Do you see this legislation working hand in hand? That it's the same thing? These are terrible accidents and things that happen, and we don't want pictures of victims out there that are being taken by these unauthorized drones.
I absolutely understand your question. Unfortunately, some ways I don't know if we'd be able to necessarily stop that from actually happening if they're flying legally. I don't know if we could stop that. Those, just like in public, just like if they were driving by and they use their cell phone to take a photograph of it, it's very much the same thing. If they're acting within the confines of the law, I think they'll be all set to be able to do that.
I find your answer interesting because you're not allowed to use your cell phone.
I'm saying if they're a passenger, yeah, sure. If you're the operator, absolutely not. We're,
Yeah, you can't
265-37A,
do
we'll
that.
absolutely write you a ticket for doing that. Yes, ma'am.
Okay. Are there any further questions? Seeing none, thank you very much, Officer. Okay, the chair is going to call Tricia Lambert, and it looks like you have Jason Levitt with you. You'd like to come up together? Okay, terrific. Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Tricia Lambert, and I'm the administrator for the Bureau of Aeronautics for the New Hampshire Department of Transportation. I have with me Jason Levitt, and you can introduce yourself.
I'm Jason Levitt. I'm the UAS planner for New Hampshire DOT Aeronautics.
So Jason's our expert on all things federal, for sure. We definitely have seen a lot of bills come forward going back to about 2013, 2014. And usually in most of the cases that we came across was the federal preemption piece and the airspace being sovereign. We worked on this, and I've sat through every one of them. We worked on this to very carefully craft to ensure that we did not have any federal preemption, that we were falling under the federal guidelines, the federal rules of regulations, so that very much like the rest of the Aeronautics Act, which is RSA 422, to put this to allow, as Lieutenant Storm had mentioned, the education piece. That is what we're doing right now. We're educating, and we will continue to educate. But there is definitely a need for those who are violating the law repeatedly, and we have seen that, to eventually at some point have some type of penalty to that so that we can ensure it's a safe airspace. Our office, or safe aviation system, our office is responsible not only for the safety of aviation in the state, but also aviation education. So we work on both sides of that. And I think that the group that put this together really was thoughtful in that and really put it down to what we really needed to accomplish that. As written, we support this bill. I do have one, it's really just more of a formality, is that what this bill doesn't do is we would like to show it that it reaches over into 422 and we have some draft language we can hand out to you, so that the aviation people can see it and know to point over to the criminal code and then the criminal code will have this language. So I think it's just a formality piece. Since they are pilots, they're going to look to the Aeronautics Act. So we want to have some kind of language for that. So we would like to see it amended to reflect that.
Okay.
Other than that,
Thank you for your testimony, Mr. Levin. Do you have anything you'd like to add?
Well, that sums it up. A lot of people worked hard on this to make sure it was appropriate both federally and for the state. And as Trish said, we definitely support it.
Thank you very much. Are there any questions from the committee? Seeing none, thank you. If you would pass that over to our committee aide, that would be terrific. Okay, are there any other members of the public who would like to speak to Senate Bill 460? Okay, seeing none, we'll close the public hearing. Senator Altshuler, you're up. Going to, yeah, I know. Can you believe it? Are you testifying on this or?
Yeah.
Oh, you need to stand. Ooh. Okay. We're going to go ahead and open the public hearing on Senate Bill 579 and recognize the prime sponsor, Senator Altshuler.
Thank you.
Welcome back to the committee.
Thank you very much. Good afternoon, Chairwoman Carson, honorable members. For the record, my name is Deborah Altshuler. I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Northampton, Hampton Falls, Rye, and Stratham. This proposed bill, Senate Bill 579, is in response to the many questions survivors of violence have with regards to court-ordered batterers intervention programs. These programs are utilized as conditions of parole and occasionally in mediation plans assigned to perpetrators of domestic violence by New Hampshire courts. As written, this bill directs the circuit court to study and report on the domestic violence protocol and practices available to the courts in requiring offenders to attend batterers intervention programming upon order of the court. Through ongoing conversations with survivors, domestic violence advocates, attorneys representing victims of domestic violence, representatives of the courts, and legislators, we have brought us to ask this committee to consider fulfilling this pressing need for answers to the questions of legitimacy, expertise, and efficacy in this space of batterers intervention programming for a study commission led by the legislature, not a committee led by the judiciary. There is an amendment on this as the second piece of paper in your packet.
Okay.
There is no question from stakeholders that there is a need for more comprehensive investigation into this industry and the outcomes expected by the courts when included in a court order. The legislature is better suited to bring the myriad of stakeholders together for this evaluation and prepare to present any future legislation or recommendations for rule changes through legislation. Should a perpetrator of domestic violence be ordered to complete a batterers intervention program, they would find right out of the gate the following options. And I direct you to these two actually 3 packets in the back. One is called Course for Violence, New Hampshire Domestic Violence Course. The next one is called DV Class, New Hampshire Domestic Violence Classes Online. And the third is Court Ordered Classes, Batterers Intervention Programs, BIP, as examples. As we know, the New Hampshire Office of Professional Licensure and Certification provides administrative support to more than 54 professional licensing boards, commissions, and councils responsible for licensing and regulating their professions within the state of New Hampshire. There is no such professional board guiding best practices in the area of court-ordered batterers intervention. According to the National Resource Center on Domestic Violence, evaluation is one of the best forms of program accountability. A program which evaluates its effect on batterers and victims is likely a safer program than one which does not evaluate. At this time, there are no New Hampshire programs in place conducting evaluations of these types of programs. That is of deep concern. As reported in the New Hampshire Domestic Violence Fatality Review Committee report, between 2020 and 2021, 13 people lost their lives to domestic violence homicide in New Hampshire, representing 59% of all homicides during that time frame. While the total number of domestic violence homicides has decreased since the previous 2018-2019 reporting period, the rate of domestic violence homicides has increased. Domestic violence homicides accounted for 55% of all homicides in 2018 to 2019. National research and New Hampshire data show that domestic violence is more lethal for women than men, though men are also victims of domestic violence. In the last reporting period, 2018 to 2019, 86% of New Hampshire's domestic homicide victims were women. 2020 to 2021, however, saw a change in trend in New Hampshire. 60% of New Hampshire's domestic violence homicide victims were men, 7 out of 13. 80% of the perpetrators of domestic violence homicides in this period were also men. As in the 2018-2019 reporting period, the leading cause of death in New Hampshire's domestic violence homicides in 2020 through 2021 was firearms, accounting for a little under half of the homicides in this period, 5 of 13. This report also details the lethality assessment program data for the 2020-2021 reporting period. And in the data collected shows that 3,203 LAP screens, that's lethality assessment program, were completed, and of those, 52 screened in as high danger. Information and data about the survivors of domestic violence seeking services from domestic and sexual violence crisis centers is also included in the report of the New Hampshire Domestic Violence Fatality Review Committee 2020-2021 biennial report. Important to note is information and data about the survivors of domestic violence seeking services from domestic and sexual violence crisis centers. 24,798 people sought services for domestic violence, stalking, sexual assault, and human trafficking from the state's 12 crisis centers. And the data shows that 70%, 17,489 of those were seeking services for domestic violence. Thousands of people sought protection from domestic violence and stalking in our courts. 6,775 domestic violence petitions, 4,278 civil stalking petitions were filed by people requesting protection from abuse. These numbers alone should show how critically important it is for us to get this right and curb violence in the most evidence-based, professionally evaluated, and meaningful ways possible to serve people experiencing domestic violence. If the New Hampshire courts are going to continue to use batterers intervention programming in its ruling, we need a thorough look into the standards and practices of this industry. I hope the committee will also see the need for study of these programs, why we send people to them, what we hope to get out of them, and how it serves our community safety goals. One of the co-sponsors of this bill, Representative Zoe Manos, is not feeling well and thankfully is resting at home and keeping her germs back on the seacoast. We thank her for that.
I wish it worked that way.
Yeah. So she has a statement I would like to read because she would be here testifying to this. You have it in your emails. She says, I regularly represent victims of domestic violence. I have had frustrating experiences in both the Circuit Court Family Division and the Circuit Court District Division. Last year, a batterer who admitted in his criminal matter to assaulting my client was ordered by the district court to attend and complete a batterer's intervention program as a condition of his suspended sentence. The batterer attended personal counseling, which focused on alcohol treatment, bio-LADAC, and anger management, not a batterer's intervention program. I consulted with Dr. Scott Hampton, the director of Ending the Violence. Dr. Hampton is a nationally recognized expert in the treatment of domestic violence and a member of the Governor's Commission on Domestic Violence, Sexual Assault, and Stalking. I contacted Dr. Hampton because I believed that the personal counseling with anger management course that the batterer completed failed to meet the order of the Circuit Court District Division and was contraindicated. According to the comment under Protocol 19.4 of the Judicial Branch's Protocols for Batterers Intervention Programs, and that you have also included in your packet, it has a gray bar across the top. Quote, the statute does not authorize anger management courses. Anger management programs assume the abuser has no control over his or her behavior, whereas the batterer intervention program assumes the defendant chooses when and who to abuse. Despite Dr. Hampton's agreement and written opinion that the personal counseling and anger management course that the batterer completed was contraindicated and was not a batterer's intervention program, the police prosecutor took the position that there are no specified or uniform standards across New Hampshire for batterers' intervention programs. The police prosecutor was not willing to bring the case forward for judicial review as to whether the defendant had violated the terms of his suspended sentence. So I give you an example of why we need this, the statistics that bear that out, and ask you to approve Amendment 0338S for Senate Bill 579, and happy to take questions.
Thank you very much for your testimony. Are there questions? Senator Chandler.
Thank you, Madam Chair. I'm looking at the course for violence, and it says that it is nationally recognized. By whom?
It's an excellent question. Also, I thank you for the question because I personally, and as a former advocate for survivors of domestic violence, take deep umbrage to the idea that you could take a course for domestic violence, not domestic violence prevention or addressing problems of domestic violence. I find it glib and disrespectful. There is no national certification. There are programs that certain states will try to focus and move their programs through, like the Duluth method, but that is also, as we are moving forward, we're finding that that method is actually pretty gender specific and doesn't address some of the broader problems.
Thank you very much.
Thanks.
Are there any further questions? Senator, I've got a question here. In your written testimony, you have 2020 to 2021, 6,775 domestic violence petitions and 4,278 civil stalking petitions were filed. Do you know how many of those were actual permanent protection orders?
I do not. These statistics are directly from the New Hampshire Domestic Violence Fatality Review Committee's biannual report. They're provided to you as a demonstration of the level of the volume of problem that we are addressing in the courts.
Just to follow up, is there any way that you can get the committee that report so we can have it?
Oh, it'd be my pleasure. Yes.
Okay.
Yes.
Terrific.
It's really long. Can I send you a digital copy? I mean, it's yay thick. I'm happy to print it out.
The link will be fine.
I will send you the link, but if you would like a hard copy, I'm just giving you the heads up. It's about yay thick.
Thank you very much. I know I appreciate that. Are there any further questions? Okay, seeing none, thank you very much,
All right.
Senator.
Thank you.
Okay, the chair will call Pamela Conley. Good afternoon, Ms. Conley.
Good afternoon. Good afternoon, Madam Chair, members of the committee. My name is Pamela Keilig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. As Senator Altshuler mentioned, we regularly serve nearly 14,000 victims and survivors every year. Just to quickly answer your question about the protective orders, on any given year, between 33% to 43% of final orders are granted, but the report does cover those details, so when you get a copy, you can read that there as well. I'm here to support SB 579 and also support the amendment. The coalition finds these better intervention programs really critical in terms of as an accountability measure for our domestic violence offenders in New Hampshire. As Senator Altshuler mentioned, domestic violence is not an issue with anger. Better intervention programs are not equivalent to anger management programs. And we know that domestic violence offenders typically can control their anger just fine. The use of violence and aggressive or angry behavior is a specific part is a deliberate tactic to maintain power and control. So it's really important that we have, suitable programs that distinguish and differentiate those two things. And specifically, batterers intervention programs are both there to ensure victim safety, but also make sure that accountability is maintained. Unfortunately, in New Hampshire, we don't have a reputable list of providers or adequate funding for this accountability measure, and this bill is a great step to help us get on the right track. There were standards for batterer intervention programs, but they were last updated more than 20 years ago, so we're long overdue for revision and review. And we just, as the coalition, really support any efforts to standardize this type of programming as an important public safety measure. We know that in 9 out of 10 cases, a person is likely to be returned back home after abusing someone. And it's really important that we ensure that there has been some effort to use evidence-based programming to get them to be accountable for their actions and to try to change and, of course, prevent any further violence. And I think just to close, we are aware that regularly victims and survivors request batterers intervention programs during the protective order piece because they really want to be able to be safely with their partner. So this is something that survivors want as well. And we really just support efforts that will ensure further safety. And I do have a colleague here who is a subject matter expert. So if you have any more specific programs, I'd be happy to invite her up. Thank you.
Thank you. Are there any questions? Ms. Kylie, there's a couple of questions I have, both on the bill and the amendment that replaces the bill. Shall report in 2025, either November or December. That's outside of a budget cycle. And so if any changes are to be made, do you think that report should be given much sooner than 2025?
Yeah, I think that's a really great question, Senator. I think when we were looking at this proposal in the bill, I think originally, I think there was a shorter window, and I'd refer back to Senator Altshuler too. But then we realized that the extent of research and looking into it to make sure that we had a suitable proposal, I think extended that timeline. But I think that raises a great question. We'd be amenable to something if that's suitable to the sponsor. But I think that's a really, really important point to raise because we'd want to make sure that it aligns with the budget year.
Thank you. I have another question. You, as well as I and Dr. Hampton, we all serve on the Governor's Commission. Do you think it would be more appropriate that the Governor's Commission do this rather than the legislature? Because the commission encompasses a large group of individuals, including the court, including legislators. If the request is made, they could probably put together a subcommittee and start looking at this maybe next month, March, instead of waiting until June or July, when this will finally get signed, and then you gotta put together the committee, the commission named and everything. So do you think that that might be a better pathway than actually setting up a separate commission?
Yeah, thank you so much for the question, Senator. And I know Dr. Hampton may be able to speak specifically to some of the efforts that have been introduced to start looking at these programs. I think there is definitely a benefit to allowing the Governor's Commission to explore this topic, but I do think that this could help expedite it a little bit faster, potentially, or at least give the legislature an opportunity to weigh in as well. Thank you.
Okay, thank you. Are there any further questions? Okay, seeing none. Are there any other members of the public who would like to speak to Senate Bill 579? Okay, seeing none, we'll close the public hearing.
Want a candy? Sugar? You need sugar? Candy. Go get one.
Because we have rules for the past month. I was telling Senator Whitley, for the past month, this room has been packed with people, and all of a sudden, it's like, we're still hearing bells, and there's hardly anybody here. It just seems strange. I don't think so. Well, but you didn't even sign up to testify, so.
There's unbilled.
What is it?
Regular, yes.
What is it? Oh, in the house, huh? Why, is it your bill? Is it? Oh, jeez, okay. We haven't had enough, no, just a joke. Seriously, because we've been moving. Yes, I know. Okay, I'm gonna go ahead. We're gonna go ahead and open the public hearing on Senate Bill 578 and recognize the prime sponsor, Senator Prentice. That would be great.
Right, and if you need a few minutes for a little relaxation before we go, I'm good.
We're on a roll,
Okay.
believe me, after.
Great, then I'm going to
Month
keep
we've
you on
had.
that roll. Before I introduce, do you have the amendment? This is a replace all.
No.
Okay.
Oh, wait a second. Nope, not yet.
Okay, why don't we get that out to everyone?
Thank you.
I want to make sure I am.
Stuff, throwing stuff around. This is a replace on the.
Okay.
All right, here, I'll give you good luck, or good measure, as they say. Okay, all right.
Good afternoon, Senator.
Good afternoon, Honorable Chair Carson, members of Senate Judiciary. For the record, my name is Sue Prentice. I'm a state senator from District 5, covering 15 communities, large part of Grafton, part of Sullivan County, and one in Merrimack, the wonderful town of New London. And I just want to assure Senator Gannon that I still have my Razzles in my bag that you gave as a gift. I came across that this morning. I'm like, I'm going to see Senator Gannon today. So I am here today to introduce Senate Bill 578. And first I'm just going to give a brief overview of the amendment to put this all into context. But this has been narrowed. I've narrowed this bill down to really the scope to be pretrial electronic monitoring and indigent and of the indigent are the only ones that this would apply to. So the scope of this is not all pretrial services. It is electronic monitoring, and this would only apply in indigent circumstances. So I just wanted to put that out there. And I do think, Senator Carson, that there may be one further amendment in terms of an order of action that I want to discuss, but let me just talk about this bill in general. So this goes back to last year when us in the Senate were watching the work over in the House Criminal and Justice Public Safety Committee on the state criminal justice system, talking about bail reform in particular, and we know that's come into this year. And during one of these sessions, one of the speakers from county government about their system came in, and they were talking about their experiences with the bail system, including the use of electronic monitoring bracelets. So this individual, or actually individuals from these county community corrections, said something that really stuck with me, which was that individuals who were unable to pay for so they've been charged with a crime, they're not guilty. We know that the judge has determined them not to be a flight risk, not to be dangerous. They're eligible for electronic monitoring bracelet, but if they have to pay for that bracelet, and if that bracelet is this device is $5 a day. And for some, that's $150 a month, which if you're indigent and you're already living on that margin, this could be a make or break difference. And so they were given the opportunity to actually do manual labor, chop wood, rather if they didn't have the funds to pay the bill. And so it just seemed to me that maybe that isn't the kind of New Hampshire or community that I think about, especially, again, innocent until proven guilty, not a flight risk, not dangerous, living on the margin. How can we keep them out in the community with their families, gainfully employed, rather than the more costly option of if they can't pay for this, and in some places the labor option isn't available, they can't pay for this, then they're going to end up being being detained and occupying a cell, which can range from $100 to $300 a day. So tools such as electronic monitoring bracelets can be, again, the difference between having to wait months in jail or awaiting trial in the community with their families, working in a way that I think that we would all envision is more productive within society. So as I've alluded to, but more specifically, those awaiting trial, this can cause them, or they're in jail awaiting trial, to lose their jobs, potentially the roof over their head, sometimes even the custody of their children. If the court has determined that someone, again, is not a danger, can be released safely, use an electronic monitoring bracelet, then we have an option here. So we're not, again, talking about, someone who's been found guilty of a crime. I keep reiterating that because it's come up in some of the correspondence with folks. They're like, who exactly are you talking about here? So the judge has made this determination that they are eligible for an electronic monitoring device, and they are not guilty. They have not been found guilty. So that's really the bulk of this and my testimony. I'd be happy to answer any questions that you have. Again, we are looking to just limit the scope of this to the indigent community, and again, indigent can be out in the community, again, staying, working, living with their families, rather than occupying a cell. And if you look on lines 16 through 22, it actually talks about language here that says the court shall develop a uniform criteria to evaluate and determine whether defendant is indigent or not indigent for the purpose of the defendant's ability to repay the cost of their own pretrial electronic monitoring or the use thereof. One of the things I found in looking at different statutes is that we didn't have, say, one consistent definition. It would be embedded in different parts of judicial related statutes. So it was if you say indigent, there wasn't exactly one place you could go to that was universal. So I think that this might clear up and give the authority to the court to make that uniform determination.
Okay. Thank you for your testimony, Senator. Are there any questions? Senator Goodman? I have a question, Senator. What happens if they break it? Oftentimes, there are a lot of conditions put on wearing an ankle bracelet, and oftentimes that you can't leave the house, you can't do this, you can't do that. What happens if the person deliberately breaks it, and either finds a way to cut it off or destroy it somehow? Should they be responsible for paying for that?
So thank you for the question, Senator Carson. I think that's a really valid and good question. I can, let me talk, if that'd be okay, someone in the judicial branch about how that determination would be made, and we could enter that in here, especially if it is done with malice or intent. I can see what your direction is. And if I may, I don't know if you have another question, because I forgot to talk about the order of implementation, which I mentioned.
That was my second question.
All right, so the way this is written, and again, I've been, tinkering with this, and I'm sorry, right up to the last minute, trying to get it right. The way it's written, it actually makes the determination at the end of indigent rather than at the beginning. And I think what I have to do is amend this to make sure that that determination is made up front. So it's clear that that's up front, not at the end.
Okay.
So that should be the order of business.
Okay. All right. Thank you. Are there any further questions? Seeing none, thank you very much, Senator.
Okay, thank you. I'm going to turn to my seat and have some razzle.
Are there any other members of the public who would like to speak to Senate Bill 758? Please come forward, sir, and identify yourself for the record.
My name is Albert Schur. I'm a professor of law at UNH Franklin Pierce School of Law. I'm also a elected police commissioner in Portsmouth. I want to identify for the committee, I'm in support of this bill. I will note for the committee, there's two bills that will come to this committee that are coming out of the House. One is HB 653, which is a committee that sets up, that asks the ICJJC, the Interbranch Criminal and Juvenile Justice Council, to take a look broadly at the issue of pretrial services. And it identifies Representative Terry Roy as the chair of that ICJJC. So the feeling was the House Criminal Justice and Public Safety did about 3 months of hearings last fall. And there was a lot of testimony that it's important going forward for the state to do everything possible to have pretrial services in every county, not just in those counties who currently can afford them, like Rockingham, to some extent Merrimack, to some extent Cheshire and Hillsborough. And so that's happening. Number two, SB 250, and this committee will see that bill. It's a HB 653, so this committee, that has passed the House, and so this committee will see that bill sooner probably rather than later. So I just wanted to identify that. And then SB 252, which was substantially amended by House Criminal Justice and Public Safety, has in it language concerning electronic monitoring. And allows for electronic monitoring in certain circumstances, and in line with this bill, does not require a person who's found to be indigent to pay for electronic monitoring. So that is coming back to the Senate. I don't know if it's already in the Senate or it's coming back. I believe that bill has been passed by the House. There's two bills, I believe SB 240, 248 or 249, can't read my own handwriting, and HB 318, which are, for lack of a better term, hanging out in House Finance because they cost money. But there's a package of 4 bills that will come to the 2 Senate bills, 2 former, what were originally Senate bills substantially amended, and 2 House bills. So that stuff is coming to likely this committee. I don't know whether this committee wants to hold on to this bill until it sees SB 252 and, well, 252, well, it won't see 252, I guess, whether when it sees HB 653 or not. But I say that for information purposes.
Thank you very much for your testimony, Mr. Sheriff. Senator Abbas has a question.
Thank you, Madam Chair. So what happens now if there's someone that's to be released under pretrial conditions, but they don't have the money to pay for the services?
If specifically it's electronic monitoring, it's up to the judge. I have heard of a number of cases where the judge says, all right, I'm going to put you in jail because you're not going to pay for electronic monitoring. So, which really doesn't accomplish much. It costs the state more money. But I don't think there's any consistent.
Follow up? Was that said on the record?
No. That question wasn't asked during the hearings about what happens. There was an appreciation that there was a lot of variation in electronic monitoring. And the idea was to try and regularize it and make it fit at least in the particular area. And it has a number of regulations or provisions that go with it, but that's kind of a non-answer. I apologize.
But it's true now. Aren't courts allowed to waive a lot of these expenses as is? I understand there's some belief that maybe judges won't waive it because of the fiscal impact of that. But I guess unless they're saying it while sitting there on the bench, and that's why they're, I guess, declining someone pretrial release. I feel like they can already waive these expenses.
Well, depending on where one is, electronic monitoring it's a third-party vendor that provides it. So you can't tell I don't know that you're able to tell the third-party vendor, you got to do this and you're not going to get any money for it. That was part of the reason for the language put in SB 252.
Follow up?
Yeah, follow up. Excuse me. Thank you.
No,
I thought though that it's the court is billed, but doesn't the payment go through probation department, or is the practice that they actually pay the third party vendor directly?
I do not know the answer to that.
Thank you.
Okay. Are there any further questions? Seeing none, thank you very much. Are there any other members of the public that would like to speak to Senate Bill 578? Okay, seeing none, we'll close the public hearing. Okay.
Thank you, Madam Chair. Senator Darrell Abbas. I represent District 22, serves the communities of Pelham, Salem, Plastow, and Atkinson. This is Senate Bill 321. This language actually must look very familiar. This same identical language actually passed in the Senate 2 times last term. Did stall in the House both times. One of those references was Senate Bill 92 from last term, which was a much larger comprehensive bill. This really focuses on one isolated section of the bail chapter. It has to do with someone's been released on bail, but consistently or repeatedly defaults at subsequent hearings by failing to appear. There's been, my understanding, the original intent of the law was if someone were to continuously default at subsequent hearings, either 3 times in a 5-year window or 2 times on a single case, it would, you can see what the existing law is, there shall be a rebuttable presumption that the release will not reasonably assure the appearance of the person as required. However, that's been applied differently throughout the state, where there's been individuals who default several times over by they get released on bail, whether it's on personal recognizance or cash bail, it's all the same. They just don't appear at the next hearing, and that creates a default warrant. It's a waste of resources for the court. It's a waste of resources for law enforcement. It's a waste of resources for the prosecutor. There's only a certain amount of cases that will be scheduled, and we have people just simply not showing up with little accountability. What this does, this attempts to clarify that language to make it clear that once you hit that point where you continuously, again, you missed 3 hearings within a certain time period, or you defaulted twice on the same case, that there's now a presumption that it will now read that you shall be detained pending pretrial detention. So that's, I think, we take the original language, and this actually captures the intent of what it was supposed to be. I will say that for someone who's represented people in court hearings, normally when the next date is assigned, it's often set in the courtroom. So I'll be there. My client's also there. I also tend to send friendly reminders to clients when there's court hearings. I understand not everyone has email, not everyone has phones, but generally some courts, they'll walk up and hand you a written notice on top of it. But this is not talking about missing 1 hearing. We're talking about now 3 times or 2 times in the same case. So it's repeated, and to have that happen repeatedly is unacceptable. If someone's charged with a crime, there's a responsibility in respect that should be given to the court when you show up at those court dates. When we had this policy, I heard people object to it saying, well, people have to work, they get a new job. I understand that. It's very rarely does a court deny a continuance or a change of date, especially to accommodate someone who just got a new job, even if it's the person being charged. There's a process you have to ask for. You can't just not show up. But knowing that you have to be there and say, well, I have something more important to do, not necessarily recommended. I understand if there's a family emergency. My experience, again, if you came across a circumstance where there was a family emergency that caused someone to miss a hearing, the court would likely take that into consideration as when they consider whether or not you should be held, because it is a rebuttable presumption. And if you had those emergencies, or perhaps the defendant was in the hospital, I think that would be a good explanation why you miss a hearing. That's just how I look at this. But in my experience, if you have the right circumstances, the person won't be detained. But simply just not appearing without consequence is unacceptable. There is literally no point of having conditions of pretrial release if there's no consequence for not abiding by them. Now, there is a printout that was passed around. This was recommended as some clarification language. What I put forward is I literally took the identical language from Senate Bill 92 from last term. I took that. That's what this bill is. All this does as a proposed amendment, the look back period would be 5 years, which is the current look back period is 5 years as opposed to 3 years. But it's still the 2 times in the same case, but it otherwise captures the same intent as the bill. I did put in for the amendment. It just hasn't been drafted yet, but that's cut and paste for what I sent to OLS. So I'll be glad to take any questions on either the amendment or what has been filed.
Senator?
Thank you, Madam Chair. So in effect, the only thing, thank you for taking my question. The only thing this bill does is, the only change is that it would now mandate detention. Am I correct?
I don't think mandate is the correct term. What it does is that it says that the person shall be detained in a pretrial detention based on the rebuttable presumption that the release will not reasonably assure your appearance at the next hearing. So you have an opportunity to rebut that presumption. The existing law says you have the rebuttable presumption, but it doesn't say that you have to be, the presumption is that you're being detained. So why are you rebutting this presumption if you're not being held anyway? So that's where the kind of the confusion in the law is. And I think the original intent was, if you're going to be rebutting the presumption that you will show up at the next hearing, it's because there's an intent for you to be held. But it doesn't really state, is there a presumption, like what is the presumption that you're overcoming here or trying to rebut? It doesn't really make it clear. This makes it very clear.
Okay, and if I may
Follow
follow up. But currently, it is possible for that person to be detained.
It's possible. What's happening is it's being applied differently. And from when I looked at, well, why is it being applied differently? Why is the person not being detained if they miss multiple court hearings without any justifiable explanation? And the response is that, well, they're not required to be held. So that leads me to think, well, what is the consequence of not abiding by the conditions of your release? And why is they're even facing a rebuttable presumption if there's no consequence of their actions? So to me, that either way, what is in the law, the current law, is not really, to me, complete. It kind of contradicts itself. So I think what this would do makes it clear which direction you're going. And that if you do miss 3 hearings in a certain period of time, now whether it's 3 years or 5 years, we can discuss that as a policy, or twice in the same case. So just remember, the prosecutor's ready to go. If it's an evidentiary hearing, you can even have witnesses there. You could have, obviously, the court schedule it. They have to docket that. They have to pull the file. The prosecutor prepares for that. I presume if they have counsel, they show up for it. There's often police officers who are present as witnesses. You have civilian witnesses, but police officer witnesses, they are present, and they're also sometimes getting paid overtime. Everyone gets here for a hearing, and then a person doesn't show up. And so a default warrant issues, the case can sit idle for a period of time, but it happens multiple times over. And that's some of the issues with bail now, is that people are being released, and then they don't show up at any more hearings. Their goal is to get out, they're out, and they're out. And if someone does that repeatedly, it can be taken into consideration. And if they're going to keep doing that and they're going to be released, now they need to explain, well, if we do release you, what makes you think you'll now finally show up at the next hearing? Because the track record is they won't.
Thank you.
Okay. Are there any further questions? Thank you very much, Senator.
Thank you.
The chair will call Albert Scher.
Thank you. Thank you. Sure. CHP, law professor, school of law, like business enforcement. I think my difficulty was with this bill is that it doesn't accomplish what. Sorry, it does not accomplish what Senator Abbas wants to do by the wording. I think he intends that if someone meets the criteria of the first part of this bill, that then they shall be detained pending a hearing. But the way the bill reads now, it reads, the person shall be detained in pretrial detention based upon the rebuttable presumption that release will not reasonably assure the appearance of the person. That reads like there's no hearing. They're automatically detained and that's it. And I think probably everyone would agree that's unconstitutional. There's got to be a hearing under Stapleford versus Perrin, under State versus Poulakakis, under U.S. versus Salerno. When you're taking away somebody's liberty, you're at least entitled to a hearing. I think it's easily fixable. I think, and I was just figuring this out as Senator Abbas was testifying, and Senator Abbas and I have had hours of conversation about this issue. I think it'd be a understatement. I think if an amendment were made that in the last phrase, it reads, the person shall be detained in pretrial detention, and then add the language, comma, pending a hearing within 24 hours, comma, upon the rebuttable presumption, et cetera. I think that would accomplish Senator Abbas's purpose. It would abide by the Constitution. I recognize that this issue of people failing to appear is a significant one in some courts. I think the way this is written, it has some flexibility in case somebody actually couldn't get a ride, had employment problems. It doesn't automatically send you off to jail the first time you meet a court hearing. It has some, it's written, and it was originally written with some give in what happens when someone fails to show up for court. My preference is for the 5 years rather than the 3 years, but I understand the concern of some. But I think with that suggestion of an amendment, it would cure what I think reads, unintended probably, but reads like there's no hearing. It just happens.
Okay, thank you very much for your testimony. Are there any questions? Senator Whitley.
Thank you, Madam Chair. If you don't mind just emailing that proposal to the committee, I think that would be helpful.
I will do that.
Thank you.
Thank you. Okay, any further questions? Seeing none, thank you. The chair will call David Rothstein. Am I correct? Okay.
Although I usually say Rothstein is perfectly appropriate. My name is David Rothstein. I am a criminal defense attorney. I spent most of my career with the New Hampshire Public Defender, over 30 years. I was one of the directors of the program when I left. I am now practicing primarily criminal law in the Exeter area, and I'm here on behalf of the New Hampshire Association of Criminal Defense Lawyers in opposition to the proposed bill. A few points, not to belabor what's been said. I had the same reading of the bill that I think Professor Scher did and the senator did, where I read it, and it may be my mistake, but I read it to basically say 3 strikes and you're just out. You sit until the time that your trial happens to come up. And I don't believe that was the intention, but I don't think that should be the intention for constitutional reasons and for practical reasons that I'll get into briefly. There is currently language that we have in the law right now that establishes clearly a rebuttable presumption of detention on certain circumstances, and I don't see the need to amp up or to change that language. I agree with Senator Abbas that this provision, like many other provisions in the law, you have language, and then on the ground, in terms of the courts, you have the application of the language. And the application of language is going to reasonably differ depending on the case. If you have a person who twice in one case, one time they ran to Kentucky to avoid being prosecuted, the next time they ran to Minnesota to avoid being prosecuted, that person is going to be treated differently than someone who happened to be incarcerated in another place and couldn't make it, someone who was in the hospital. Someone who was in the throes of substance use disorder, very, very big and very, very real. Mental illness, very, very big and very, very real. People without homes, very big issue. People without phones, very big issue. People who are simply just not very organized. And I don't mean that in any sort of malicious way, but they have things going on in their lives that fortunately we don't have. I have missed court. I hold court sacred. I get to court early. I am prepared. I've missed court. I think every lawyer has missed court, despite all of the infrastructure we have, despite how careful that we are. So I do think it's dealt with differently. I think sometimes it's dealt with very sharply. I think that prosecutors and prosecutors are capable in certain cases of making arguments. This person is trying to dodge process. This person isn't just forgetting. This is a pattern with this person. Since 1978, they've missed court every single time that they've been charged with a crime. And here in this case, we tried to give them a break. Well, they missed court again. This person's bail should be revoked. On the other hand, another person who maybe has missed court 3 times in the last 3 years or the last 5 years, but they are a person who has these issues, a person who missed court, a person who did it through accident, mistake, misfortune, the circumstances of their lives, rather than some sort of conscious desire to avoid process and to frustrate the system in the way that Senator Abbas is talking about. The other problem I have with the bill is that you have danger and failure to appear. These are, of course, the 2 pillars of the bail determination system. I would submit to you that although these 2 things are co-equal, danger is a more serious thing. If you're a judge and you've got somebody in front of you that you think is a danger to themselves or the public, I would suggest that that gives you a sort of heightened awareness. But if you look at the danger provision of the statute, even if a judge finds a person to be dangerous, there's a safety valve where they do not have to detain that person. They can give them intensive bail to include the electronic monitoring that you've been talking about, community corrections, or other intensive bail supervision. This bill, if it's read the way that I thought it was, there would be no safety valve. It would be, all right, I'm a judge, I'm looking at the statute, I count 1, I count 2, I count 3. I don't care if you were in the hospital, I don't care if you had overdosed, I don't care if you have a mental illness, that's 3. Under this statute, you're out and you sit in jail until you're detained, and there's really nothing I can do about it. There's a mention of a rebuttable presumption in the new language, but to me, it doesn't really, I'm not really sure what to do with it the way that it's written, but I do know what to do with it the way the statute that we have in place now is written. So you can have a situation where, especially where a person is not dangerous, they could end up being held in jail on pretrial detention for perhaps longer time than they would end up serving after they were convicted of the offense that they're facing. And again, this is a person who has the presumption of innocence. Even though they've missed court, they still have the presumption of innocence, just like you do if you're dangerous. So I would offer that the existing legislation that we have, while it's not going to be applied perfectly, just like no legislation is ample. I think it directly addresses this situation. I think it gives prosecutors and judges an absolute vehicle to detain somebody in appropriate circumstances, and it gives defense attorneys like myself to give a voice to the client that we represent and to argue that detention, despite the failures to appear, is not warranted in this particular case for the subjective particular reasons. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair, and thank you for taking my question. Does the current law, by your interpretation, imply that if a person were to miss the 3 court hearings or twice in the same case, that they would be detained? Because I guess when I read it, there's a rebuttable presumption, but if there's if you're not being held, what's the point of having to rebut the presumption?
So the way I read the current law is that bring John or Jane Doe before the court. Prosecutor goes through his or her record, and they say John Jane Doe has failed to appear on these 3 occasions. And you've seen the records, obviously, as someone who's represented these folks. At that point, a judge would say, well, that creates a presumption, but it's rebuttable. So turning to me, turning to my client, how would you rebut the presumption? And I might say, well, yes, I want to talk about that failure to appear in 2018. I actually represented this person. I remember that case very well. She was in the hospital. I can represent that to the court. The next time she was in a substance use disorder period of her life. The next time there was something else. So I am offering this to try to rebut the presumption of her detention. And I want to tell you where she's at right now. She's got a place to live. She's on medically assisted treatment. She's taking her medication. She's got a job. So all of these things that I'm offering you, I would submit, have rebutted the presumption of detention. Take a different case, somebody who has a string of failures to appear, and I'm just being practical here because I've represented such folks. There are some times with a person like that where the court will turn to community corrections not because they're dangerous, but to keep tabs on them. To say, look, I'm not sure you're going to show up, but I'm going to have you check in with community corrections. You're going to be on sort of this pretrial probation. They're going to keep an eye on you. And other times they'll say, I'm not sure I should do this, but I'm going to give you a chance. And you're telling me you're going to show up. I'm going to give you that chance. I'm looking at you. I'm meeting you. I'm looking at you in the eye, and I'm going to give you that opportunity. A person like that, if they're given that opportunity and they come back, I believe in all likelihood, I'm going to have a very difficult time getting them out of jail. And between you and I, that probably should be the case. But I think that also you have to look at the offense. I mean, if somebody is charged, and this is where dangerousness comes in, if somebody's charged with first-degree assault and they have these issues, they're more likely going to be detained because of the confluence of the two things, the failure to appear and the danger. So I think a lot of times these two things come together to make the decision as well.
Follow up?
Thank you, Madam Chair. But if the existing law implies that they'll be detained, what is the concern about just expressing it outright?
I think, and I mean this with all due respect, because I think these things are difficult to phrase. When I read the amendment, to me, and this is just to me, it seemed to take away the rebuttable presumption that exists in the existing law. That's how I read it. It seemed to me that if you have these circumstances that are outlined in the law, either the 3 and 3 years or the 2 in the case, then that basically rebutted the presumption in and of itself without, as Professor Schur said, without any further hearing or discussion or debate about it. And it was just a matter of simple math. It's 3 and 3 years. It's 2 in this case. That in itself establishes the conditions that amount to detention. If that wasn't the intent of it, then I misread it. I think that the present statute does create a rebuttable presumption and also allows, obviously, for a hearing. And I would agree with you that these things are applied differently, judge to judge, court to court, person to person. But I think these are calls that judges, prosecutors, defense attorneys, I think they can make these calls. And I think that we're not going to agree with these calls any more than we're going to agree with other discretionary calls that judges have to make. I do think there's going to be some difference, but I think what the law does is it gives a framework. It gives prosecutors and judges the opportunity to detain someone who is, as you would say, a repetitive person who defaults court and does not a mathematical calculation, but does a day-to-day, person-to-person, looking somebody in the eye, hearing the argument calculation. Are we going to see this person again or not? Judges will say, I just don't think I'm going to see you again, and I'm going to hold you. And judges will say, I'm not sure I'm going to see you again, but I'm going to give you a shot, and I'm going to create some circumstances that may make it more likely that I'm going to see you again. I'm going to tell you right now, if I create those circumstances and I don't see you at your final pretrial, I'm going to issue a warrant and have you be arrested. And there are many, many people who are arrested on warrants, just like there are many, many other people. I had a case just yesterday. Client failed to appear. I had just spoken to him about court the week before, and he wasn't there. It was 10 up, and I called him. He said, man, I forgot. And I absolutely believed him. I did not believe that he was intending to miss court. I explained the circumstances to the prosecutor, and he wasn't defaulted. There might be other clients who I try to call, and I can't get a hold of them. I try to write them a letter. I can't get a hold of them. What the court is going to do is they'll tell me you've got 24 or 48 hours to get a hold of your client. Otherwise, we're issuing a warrant, and the person's going to be picked up. There's going to be a bail set on that warrant, and they're going to go back to court. And they're not going to be in a good situation. Will they always be detained? I don't know, but that's obviously not a good situation.
Follow up?
Thank you, Madam Chair, and thank you again for taking my multiple questions.
No problem.
So this section is one narrow provision of a very large chapter. So it's RSA 597:2, Roman numeral 3B2.
Yes.
Right, and there's other sections in there where you can also be held or detained awaiting your trial. So in order for this to even be, whether it's existing law or what, if it's changed, if this bill passes, the court has to make that determination of preponderance of the evidence of these failure to abide by your conditions.
Yes.
When that's done, my understanding is you'll be in a court hearing. In order for the court to make that finding, there would be a hearing. So, and then if a person is detained, my understanding is in that long chapter, there's a procedure where the defendant can then have another chance to appeal that, not to the appellate court, but they can actually ask for a full, like, more like an evidentiary hearing type of situation. May not make the most sense in this case to
Right.
do that, but my understanding, this provision's under that procedure.
So
When there's my concern is that there's I'm hearing testimony that, well, it mentions this over here, but there's no court hearing. But for the court to make the finding, you would be in a court hearing in the first place. So that's when this would come up.
Yes. A couple of things. First of all, yes, you would be in the court hearing in the first place. The way I read the bill is the court makes the finding, and if it makes the requisite findings, then effectively the rebuttable presumption is met, and you don't have any further discussion about that. And I understand that that may not have been the intent, but it was how I initially read it, and talking about it with Professor Scher, that's how he read it as well. In terms of that further evidentiary hearing you're talking about, I believe what you're talking about is most often employed when it comes to dangerousness. It's called a Fergal hearing after State versus Fergal. And that is generally a type of situation where the court is holding the defendant on no bail hold initially at arraignment. And then there's the possibility for the defendant to request an evidentiary hearing because he or she is being detained generally on dangerousness grounds. It's generally not on flight grounds. So I've never heard of a later evidentiary hearing on the failure to appear piece. I've heard of evidentiary hearings on the dangerousness piece where the state would then have the burden to call a witness that could be cross-examined and such. That answers your question.
No, it does. And just to follow up, I agree. It would be unusual to have an evidentiary hearing on this because really the criteria is you just missed these hearings.
Yeah, you know how it is. They have the printout. The prosecutor has the printout. It's got default failure to appear. You get a copy of that. You try to put it into some context. It's usually not an evidentiary type of process. And I would agree with you that there are sometimes you have an initial bail hearing, and for whatever reason, maybe the lawyer at the initial hearing wasn't going to be their lawyer for the rest of the case. So another lawyer might, if there are changed circumstances or a reason, might ask for a second hearing, but a lot of judges won't give you that hearing. A lot of times you really only have that one bite to make your case on the failure to appear part.
Thank you.
Thank you very much. Are there any further questions? Seeing none, thank you very much for your testimony. Are there any other members of the public that would like to speak to Senate Bill 321? Okay, seeing none, we'll close the public hearing and we are done our business for the day. Thank you all very much. Yes.
You want